Hello, everybody, and welcome to History/Law Bite number 130, dated December 12, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Dartmouth College versus Woodward, 17 U.S. 518, 1819. This case is more commonly known as the Dartmouth College Case. And I'm sure you've probably at least heard of this case at some point in your lives, whether it be on TV or high school social studies, civics class, American government, or maybe not even till college or even grad school. Doesn't matter. Nevertheless, I'm sure you've at least heard of this case, even if you don't know what it was all about, okay? The Dartmouth College case was a very important one in American constitutional law. All right. It is one of the Marshall Court decisions. Okay. All of the Marshall Court decisions were important. That much we all know. Okay. The Dartmouth College case is important because it extended the protection of the contract clause of the U.S. Constitution to private and public corporations, something that before that was previously in doubt. Okay. Specifically, if you have never heard of the contract clause in the U.S. Constitution, it is found in Article 1, Section 10. That section of Article 1 has powers that are specifically denied to the U.S. states. Okay, powers denied to the states. I'll read Article 1, Section 10, Clause 1 in its entirety. Okay, it reads, "No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold or silver, coin, a payment in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility." Okay, so those are just some of the powers denied to the U.S. states. There are many, many more powers that are denied to the states via Article 1, Section 10. But for the purpose of this video, we just focused on Section 1. And you got at the end, the states are forbidden from impairing the obligation of contracts, okay? This speaks of existing contracts, not ones yet to be made, all right? States are effectively prohibited from altering or interfering with the lawful obligation of contracts made between private individuals, and that is who the contract clause applies to. Contracts made between private individuals or entities. Okay, it does not apply to the relationship between the people and their government. All right, just to clear out any confusion. And again, the Dartmouth College case here extended that protection to public and private corporate charters. All right, so what exactly happened in the Dartmouth College case now that you have been read and understand the contract clause in the Constitution? So Dartmouth College, like its Ivy League counterparts, is older than the United States of America itself. Okay, Dartmouth College traces its history back to 1769. Okay, when it was granted a charter by King George III of Great Britain, when of course New Hampshire was still a royal colony. The charter itself created the school, established a board of trustees, gave it land, and everything else that was necessary to run a school. All right? And everything was all fine, well, and good. That is, until 1816, when New Hampshire, okay, decided that it was going to effectively take over Dartmouth College and turn it into a public institution. It was previously a private one, all right? Up to that point, all right? They took the corporate charter, other corporate properties. The legislature effectively consolidated full authority over Dartmouth, something that it previously did not have, all right? And effectively, like I said, turned it into a state school, all right? And obviously, Dartmouth was a little hot about that and absolutely positively wasn't going to take this lying down. So they challenged this, what they perceived as an unlawful action by the New Hampshire state legislature, okay, in unlawfully violating the contracts clause of the Constitution. in completely dissolving, amending or altering to such an extent the school's charter that it allowed the state to take over and govern it as it saw fit, when Dartmouth was a private institution. All right. The charter which created it was a private one between the King of England and the trustees. All right. So the matter eventually wound up in the courts, making its way to the Supreme Court of the United States. All right. And as you would expect, the arguments were heated. The New Hampshire state legislature, all right, argued that it absolutely had the right to do this, okay, as this contract was something that was made before the Revolutionary War and thus was no longer applicable to the modern era. Of course, this is over 30 years after the conclusion of the Revolutionary War, all right? And the trustees of Dartmouth College said, no, all right? This is still a valid contract, and the Constitution specifically prohibits states from interfering with the obligation of contracts, okay? The matter that the Revolutionary War was umpteen years ago is irrelevant, all right? Does not matter. This was a private contract that was made, and New Hampshire must respect it, all right? So the matter was submitted to the U.S. Supreme Court, and in a 5-1 decision by Chief Justice John Marshall, the court ruled that New Hampshire was absolutely positively wrong in its action. All right, the New Hampshire legislature essentially had no right to impair and effectively abrogate the contract, the school's charter, all right, that was made between the king and the trustees, even though it was back in 1769. All right, the contract clause absolutely protected that charter from state infringement, and the New Hampshire legislature had no right to interfere with it. You know, the contract clause was a private contract as such between the king and the trustees. It was an existing binding contract, okay, that could legally be enforced, okay? And as the contract clause of the Constitution protected such contracts, many of which, obviously virtually all of them at that point, would have been made before the Revolution at the time the Constitution went into effect, this was no different. The mere fact that the Revolution had changed the status of the colonies into states, into a new nation called the United States of America, did not matter. This was a valid contract made between private parties that the state of New Hampshire could not just uproot just because it wanted to, okay? New Hampshire was wrong on all fronts, you know, for doing this, all right? Marshall emphasized from his decision, okay, that the term contract with respect to the contract clause applied to individuals, agreements made between individuals, okay, transactions involving property rights, okay. Contracts for the purpose of the contract clause are not between citizens and the government. The term contract with respect to the contract clause completely and entirely covers transactions of property between individuals, okay? And in this case, the king and the trustees, all right? So, with that being said, all right, the Constitution protected Dartmouth's status, all right? And New Hampshire essentially had to return all of which it had taken from Dartmouth, and the school's previous status was restored. The New Hampshire state legislature could not do that. And so the primary effect, all right, the ultimate effect of the Dartmouth College decision was to extend the protection, excuse me, of the contract clause to public and private corporations, okay? The contract clause was extended to protect corporate charters from state infringement. Okay, that is the essential holding, all right, of this decision, that states essentially were not permitted to interfere with validly made corporate charters, whether they be public or private. All right. Now, the decision was not popular in 1819 and did indeed cause a backlash Many states, in response to the Dartmouth College decision, passed laws guaranteeing them the right to revoke corporate charters at will. And of course, the courts have not allowed that to occur as much as the states would prefer. All right. However, through time, the courts have become a little more lenient with respect to state interference with corporate charters. All right. As long as their interference just does not completely have the effect of such as harming members of the corporation, the stockholders, and things to that nature extent. All right. So when the state wants to interfere with a corporate charter, it basically has to tread a very fine line and not harm that corporation in doing so. Otherwise, it could and indeed validly be perceived as a violation of the contract clause of the Constitution. All right. Contract clause is not something you hear about very much in modern times, but with respect to business law and corporate law, it very much is still a binding provision. All right. Very much a binding provision and protects contracts from the state's tampering. Contracts that are already in existence, not future contracts. Contracts that are already in existence, okay? So again, the essential holding of this decision was that even though the contract here was made before the revolution, all right, that did not change the status of the contract. This contract, this corporate charter between the king and the trustees was a valid contract, okay, between private parties that the state of New Hampshire was prohibited from interfering with, okay? And quite simply, the contract clause did not, explain the nature of the relationship between a government and its citizens. The contract clause was created to protect contracts between private individuals or entities, with respect to the transfer of property rights, all right? Transfer of property and other rights there too. The contract clause protected the interests of private individuals or entities, okay? It does not speak of the relationship between the government and its citizens, okay? And this decision had the effect of extending the protection of the contract clause to public and private corporations, okay? So if you have any questions or controversies about the contract clause or about this in general, leave them down below and I'll be happy to answer them. Thank you so much for listening to this History/Law Bite. I've always enjoyed doing the Supreme Court decisions. They're very interesting, sometimes out of this world. All right. So if you haven't subscribed to my page, I invite you to do so right now. Just hit that little red button. All right. And click that little bell so you get notifications when new videos are posted. Okay. Again, I appreciate you. Thanks for listening. Take care. Stay safe out there. And I will talk to you at the next History Bite. Peace.